Right. Welcome everyone to our webinar on marriage-based green card options. My name is Katherine Del Rosario. I'm an attorney with McEntee Law Group here in Chicago. If you'll bear with me, this is my first webinar, so there's a lot of tech things happening if you see me looking around. But I know this webinar will also be available as a recording if you weren't able to make it today. Just to let you know a little bit about myself, I am a proud Chicago native and Filipino American. I've been practicing law with this team for 2 years. My practice is both in family and employment-based immigration. All right, and thank you to everyone who is attending. As Liz said in the chat, if you have questions, you can put it in the Q&A. I'll wait till the end though, because I would imagine we're going to address a lot of common questions or misconceptions during the presentation, but I'll definitely answer anything that we haven't covered at the end. All right, so we'll get started. Okay, just a few quick housekeeping things. As a reminder, everything that I'm sharing today is meant to be general information. I am a lawyer, but I'm not your lawyer, so I might be looking at just in case, but you'll want to get legal advice from either an attorney or an accredited representative, just because every person's case is truly different. And we are going to be talking about timelines and processing times with various government agencies. Just know that these are always subject to change. And if you are going to use an attorney for your case, it's best to go with someone that does practice family-based immigration regularly and currently, just because we really do rely on very recent trends and on kind of the intel and advice that is shared among our immigration attorney network. Okay, and here is an overview of what we're going to be covering today. I'm going to talk about the I-130 immigrant visa process, which is essentially the green card process, but from abroad. And then the green card process, which is the stateside version. We're going to talk about what a bona fide marriage means and how to prove it. We'll talk about the financial sponsorship requirements, the interview if you have one, and then at the end, as I mentioned, we'll leave room for questions. Okay, I wanted to go through some basic definitions. There are a lot of terms and abbreviations thrown around in immigration, and I will always try my best to break them down for you. There's a lot, so if you don't know them, don't worry. When I talk about a petitioner, I'm talking about the sponsor or the US citizen or lawful permanent resident or green card holder. And when I say beneficiary, that's the foreign national that's legally married to the petitioner. And when we say legally married, we mean that the couple has to be married, and they can be married anywhere in the world. It doesn't have to be in the US, just as long as the marriage is valid in the country that it took place in. So if you follow that country's rules and you qualify in that country, then marriage is legal. Okay, so we're starting with the I-130 and immigrant visa process. And just to give you the big picture view, this is when the petitioner is sponsoring their spouse who lives outside the United States. The I-130 is a family petition that belongs to the petitioner, so to the US citizen or the green card holder. And all it's proving is that both of you are in a relationship, in a marriage, and that you intend to spend your lives together. The second part belongs to the foreign national, and that when we say immigrant visa, it's like the equivalent of a green card application. But in this process, it happens outside the US, it happens at the consulate. But the end goal is to live and work permanently in the United States. And here's our overall timeline for how this process works. At the beginning, the family petition is prepared and filed inside the United States. This is regardless of where the petitioner lives. This is where I will ask you for lots of proof of your relationship, dating history, marriage, and we'll go into all the types of evidence that's required there. The USCIS, which is the agency inside the US that will process this application, will review it, they'll make a decision on it. And right now we're seeing decisions made within 8 to 12 months. From there, the case will be sent to the National Visa Center. And for our purposes, this is a website where we would upload identity documents. We would fill out the immigrant visa application and submit it there. Then the NVC can take 1 or 2, sometimes more time to process it, let us know that all the documents look good. And then they send the case to the embassy where either the foreign national is born or where they're legally residing. From there, it's sort of in the embassy's hands. It's based on their schedule, how much capacity they have to set an appointment for the foreign national. They'll tell them what the other requirements are, such as a medical exam, biometrics, and all that. And then the foreign national will actually attend the embassy interview. If the visa is issued, then the foreign national will use that visa within about 6 months, usually, to enter the US. And from day one, they activate their permanent residence. A green card will be printed and mailed to them shortly, and they're able to work and travel. There are some important things to consider when you're going through this process. When you reach the NVC stage, so that website that I was talking about, the petitioner, if they are living abroad with their spouse, has to show that they intend to move back to the United States. And so some ways to do this is to show evidence of property, a residence, a job lined up, or family and community ties in the United States. They will also have to show that they meet the income requirements as their spouse's financial sponsor. We will go into what's required for that, but some of the factors involved are, do they have a job ready to go once they move here? Or will their foreign income continue once they come to the United States? And if not, are they able to get a joint sponsor? And we'll talk more about that later. Another thing to consider is that once the foreign national or the beneficiary receives their green card, they will have to spend most of their time physically present in the United States. There are some exceptions to that. So if the US citizen is, say, in the military or stationed abroad, working for an NGO or religious organization, then they're exempt. They could be exempt from that, but that's very case specific. So that's something you'll want to discuss with your attorney. Okay, and then during the I-130 process, it may be possible for the foreign national to visit the US, but once we are at the immigrant visa stage, they have to be prepared to wait it out abroad. And then just note that the physical green card isn't going to be in hand until they come to the United States and activate their permanent residence. It's the act of coming in that signals to the USCIS to print that card. There are also fees associated with this process, as with everything in immigration. These are just the government fees. So attorney's fees vary if you're going with an accredited representative through a nonprofit, which is also great. They most likely will have fees as well. But the government fees as of today are $535 for the I-130, $445 for the immigrant visa fees, which are paid to the National Visa Center. And then the $220 is paid at the very end. When your visa is issued and before you come to the United States, you pay this immigrant fee. Okay, now we'll switch gears. So imagine your spouse is not abroad, but they're here in the United States. Whether they came in as a visitor, they're here on a working visa, maybe they don't even have status, but they're inside the United States. And so you're going to be doing the stateside marriage-based green card process. So it's similar to the I-130 immigrant visa process, but it happens inside. There's the same end goal in sight, to live and work permanently in the US. But here, I-130 and immigrant visa are combined. So it's not called the immigrant visa, it's called the green card application. And they happen concurrently, they happen at the same time. Okay, so this is what the timeline for a marriage-based green card looks like. We prepare and file the green card case, and that also includes an application for a work permit and a travel card. So you would not get that benefit in the first process that we talked about, in the consular process that happens abroad. Within a few weeks, the case will be receipted by USCIS, meaning anytime you file anything with the government, they're going to send you back a receipt. That receipt will also include a number that you can use to track each portion of your case. Shortly after that, you'll be scheduled for a biometrics or fingerprinting appointment. And it's possible that if you have gone through immigration processes before, been fingerprinted before, they might reuse those fingerprints, but it just depends. Okay, when we come to this next section here, I want to spend some time here because there's been some recent changes. Typically, a work and travel permit is issued before the green card is issued. The thinking is that while someone is waiting for the green card, they should have some means to support themselves and to travel if needed. And historically, the work and travel card used to come together like a combination card within 3 months. That was sort of standard processing time for a long time. In the last 6 months, we've seen things just change and vary pretty wildly. So some cases we see work permits being issued in a month without a travel card. And then the travel card coming, maybe 6 months later. And then in other cases, we're seeing a travel card not come at all. And instead, a green card interview or a green card itself is issued more quickly. So I think probably the main reason for this is USCIS is really prioritizing efficiency, which we love, and they're trying to process green cards more quickly, but I think it's making for, more inconsistent processing times across the board for things like the work permit and the travel card, which are really important to people. So this is an area where it's a little challenging for attorneys and accredited reps to give you some certainty or a guarantee there, because it's varying a lot at the moment. And then here's another area that has changed. With marriage-based green card cases, we would almost always guarantee an interview was going to happen, that you and your spouse would be called into your local USCIS office and be asked about your marriage and your case, and then a decision would come. And we're seeing now that as part of USCIS's efforts to make things more efficient, they are skipping interviews. They're waiving it in some cases. There's not always a clear indication of why they will waive the interview, but that has become more and more common. And so, as part of the green card case, we have the option to include a medical exam, which is required either way, but we can include it at the start, or we can supply it later once it's requested from USCIS. And, just as a matter of practice or a trend that I want to let you guys know about is if we file the case without a medical, it doesn't necessarily mean that it's going to slow anything down. But when USCIS comes to us later and says, send us the medical, sometimes it's a good indication to me that, we're kind of at the tail end of your case and a decision is coming soon. So just some things to note there. You may or may not receive a travel card, and you may or may not be interviewed. Okay, but once your case is approved, your green card would be printed within 1 or 2 months. And some key considerations here, that with the stateside process, the beneficiary, should remain in the US while their green card case is pending, unless they get that travel card. But they shouldn't leave otherwise. There are some exceptions there too. If you've got a certain type of working visa that allows you to travel and that is dual intent, so that allows you to hold non-immigrant status while you're also pursuing a green card, you may be able to travel. So you'll want to consult with your attorney about that. And then in some cases, if the foreign national, the beneficiary, has worked without authorization, or say they've overstayed a visa, those violations may be forgiven. It depends on a number of factors. So that's also something to discuss. And then some applicants may need to maintain some other status to continue working while their case is pending. The example that comes to mind is an H-1B employee who is relying on that working visa to show that they're authorized to work for their company, and they may be going through the marriage-based green card process as well, but without a work permit, they still need to maintain that H-1B. That's just one example. Another reminder here, I can't travel outside the US without the travel card or the green card. And then same thing as in the other process, that once the beneficiary gets their green card, they should be spending most of their time in the United States. The reason for that being, as a lawful permanent resident, you have to maintain that residence. Otherwise, you can compromise it. And USCIS can say, you're not, it doesn't really look like you're living here. So they may give you a hard time about keeping the green card, and they want to make sure that you're maintaining your status. There are also fees associated, of course, they're a little bit different here. So the $535 for the I-130, and then $1,225 for the green card application itself. And these are paid together during this process, since we can file concurrently. Oh, I'm seeing a lot of questions. That's great. I will definitely address those. Okay, now, whether you're going through the consular process or the green card process inside the United States, you still have to prove that you have a bona fide marriage with your spouse. And it's a funny legal term that basically means, do you have a good faith marriage, that at the time that you are getting married, is there an intent to build a life together? And the way that the government kind of organizes the proof is in 2 major buckets. So shared residence and combined finances. And I've put some examples here of the types of proof that we ask our clients to provide. So if you own a home, do you have mortgage statements? Do you have a title to the home? Maybe the loan agreements. If you rent, is there a lease agreement that has both your names on it? Do your state IDs or driver's licenses reflect the same address? Do you have utility bills addressed to the same location, and other correspondence that goes to your residence? A question I get a lot is, both of our names are not on everything. And that's also okay. So typically you don't put more than one person's name on your ComEd bill, but if petitioner's name is on like People's Gas, and then beneficiary's name is on ComEd, which I guess is not as typical, but if one of your names is on correspondence that's all leading to the same address, then that's useful, and I would definitely use that. And then the other bucket is combined finances. So we're thinking of jointly filed tax returns, joint bank statements, credit card statements, joint insurance coverage that includes, medical, dental, life, home, auto, or renters if you guys rent, and then jointly owned property. So if you own your home, you own vehicles, we'll want to see proof of that. Something I wanted to note about joint bank statements and credit card statements is if you choose if you choose to have joint accounts, I would be mindful about both spouses using that account regularly, just to show that it's truly something that you both share. I've had officers actually comb through the statements and they do notice if it's being regularly used by both people. Okay, here are some other forms of evidence that we also like to use. Photographs of you and your spouse together with friends and family over the course of your relationship, throughout the seasons, just to show like a full picture of your life together. If you have documents from the proposal, like, receipts for rings, and then evidence of your wedding. So not just photos, but if you have vendor agreements, if you've hired a photographer, a caterer, a venue, all of those things, will show your names and a date. So that can be very helpful. And then if you've been able to travel together or attend events, those itineraries, those invitations that you received, those booking confirmations that show both of you attended something together or went on a trip can also be helpful. And then affidavits are really great. So we like to use affidavits from family and friends who really know you and can speak to the relationship that you have. And I will say that, these are a list of suggested documents. But one thing to remember is that the officer is looking at the whole picture. The standard that we call it is totality of circumstances. So if you don't have one of these things, it's not a deal breaker, but we want to provide as much proof as possible to show what your relationship and marriage looks like. And not everyone's life looks the same, right? I want to make sure everyone understands that we don't all own a home, live on our own, and all that. Some people live with their in-laws. Some couples live apart for work or schooling. And so if you don't have every single thing that I named, don't panic. We can talk through what other proof you have to show. Okay, this comes up a lot. Like, what are the red flags in a marriage-based case? And it really, really depends, but I wanted to draw out some common things that I see, which, may not always sound fair, but this is sort of the reality that these are the types of things that, will perk up an officer's ears if they see. So a big age difference between the spouses, or if there's no shared language, different religion, different cultural background, if there's no shared residence, as I mentioned, if there's a very short courtship or engagement, or if the petitioner has previously petitioned a spouse, or the beneficiary has previously been petitioned by a spouse. And, the heading here says red flags, but I would also say here that these are not deal breakers exactly. And everyone's life really does look different. As long as we can reasonably explain and articulate why some of these red flags exist, it's not to say that you can't overcome them, but it's really important, I think, to talk to an attorney to really flesh out and help the officer understand, what these differences are. Because we all know, I think differences in cultural background, I think are increasingly more common. So I wouldn't be discouraged if this is something that is true of your relationship. Okay, for a marriage-based case, there is a financial sponsorship requirement. So the US citizen or green card holder, they're not only the petitioner on the case, they are the financial sponsor. They have to meet certain income requirements that are determined by the size of their household. So the way that it's calculated is petitioner, beneficiary, and anyone in petitioner's household. So these are dependents. And what we look to is the sponsor's last 3 years of tax returns, particularly the total income line, and the most recent tax return being like the most important. If petitioner doesn't meet those requirements, they'll want to consider a joint sponsor. So another person that should be a US citizen or a green card holder who also meets the income requirement. And so in that calculation, you're counting joint sponsor, the beneficiary, and joint sponsor's dependents. So it could be a different calculation and a different requirement. So it will just depend. I will say that USCIS is supposed to allow a petitioner to show proof of assets, real estate, stocks, things like that as proof of income. However, even though they offer that option, in practice, I see that they really, really rely on the tax return. So if the tax return is a little iffy, if you don't meet it, the income requirement there, then we really highly recommend using a joint sponsor. The joint sponsor does not have to be related to you, but that person does have obligations as well. And so naturally the person will be kind of close to you, because if they're willing to take on this obligation, they know you pretty well. Okay, the interview process, if there is one for you. So in the immigrant visa context, when you're abroad, there will definitely be an interview. It will happen at the consulate, and the beneficiary will attend alone. In the green card process, they may or may not require an interview, but if they do, then the couple will attend together, and it will be at the local USCIS office here in the United States. It starts by having the applicant raise their hand, take an oath, swearing that they're telling the truth, and the officer will verify their identity. They will look to supporting documentation. So not only are they looking at the case that was filed originally, but you should bring any additional proof of your bona fide marriage from the time that you filed up till present, because theoretically, months can have passed, maybe a year has passed. And so you will have generated, more evidence that just didn't exist at the time that you filed. So you'll bring all of that. The officer will review your case in detail. And then they'll ask you your story. They'll ask you about how you met, how your relationship developed, how was the wedding, and what are your plans as a couple. And so that's the typical way that the interview works. And at the end, an officer may or may not make a decision. Most often they don't, and that's okay. You'll see in the interview room, there could be stacks of cases, and it's very clear that these people are very busy. And so they may need to take time to review the case more thoroughly. And so you might receive your decision after the fact, which is totally fine. Okay, great. We have lots of time for questions. Okay. Is the timeline the same for a US citizen and legal permanent resident? So this brings up another issue, which is that spouses of US citizens are considered what we call immediate relatives, which means that technically there's no wait line for the spouse of a US citizen to receive their green card. In reality, they are waiting, but it's just the processing time, but there's no backlog for that person to receive their visa. And for the spouse of a legal permanent resident, they fall into what's called a preference category. So every month we look at the visa bulletin that's issued, and it tells us if whether or not there's a backlog, a wait time for the spouse to receive their green card. Historically, there hasn't been, but that can change. And so if it's current for the spouse of a green card holder, the answer is it just depends, because it's not just whether it's a spouse of a US citizen or green card holder. It can also matter where the petition is being processed. So there are several USCIS service centers around the country. Some of them have different caseloads, and so it just depends. But in the beginning, I mentioned that your I-130 will come with a tracking number. We can use that number to get an estimate of the processing time that it takes for your petition at the service center that it's at. Okay, is it okay for a beneficiary to visit the US with a B2 visa during the I-130 and NVC stage? Generally, yes, they could theoretically use their B2 to visit during the I-130 stage. But I would say once we get to the NVC and start uploading documents, that's when the spouse should stay abroad. The reason being is that during the I-130 stage, we haven't asked the government to change the spouse's status yet. We're just establishing the relationship. And so they're free to use the B2, which is a non-immigrant visa. But once we're in NVC territory, this is where we're asking the government to change status. So intent has changed. So it wouldn't make sense for you to use a B2 because that has non-immigrant intent. What happens if you forget the I-130A? The I-130A is a supplement to the I-130 that applies to spouses only. They could reject it. And so I didn't name the I-130A here, but you would include that. And if you forgot to, they could either reject it or issue a request for evidence and ask you to submit it. If they reject the I-130, can you submit another one? How long should you wait? So there's a distinction between rejection of a case and denial of a case. So with rejection, they send you the whole thing back and they're like, you forgot something or something's wrong with this. So send it right back to us. So in that case, you'll actually want to respond immediately. As opposed to a denial where you actually have to refile the whole thing with new fees and everything. How much time out of the year should the beneficiary spend in the US after receiving their green card? Okay, that's a great question. So you'll want to keep trips outside the US to shorter than 6 months. And definitely shorter than a year. So trips less than 6 months are fine, but once you start creeping above that, then USCIS can make the assumption that you have abandoned your status. And so that's why you want to be mindful of how long you're outside the country. In addition to that, this is relevant for later on. If the beneficiary wants to become a US citizen, which they can apply to do 3 years after they get their green card, there are certain residence and physical presence requirements to qualify for US citizenship. So that's also why you'd want to make sure that you're maintaining your presence in the US. Is visiting the US during the visa stage of the process completely out of the question? I think we addressed that. Can I-130 and 485 be filed concurrently if visa priority is not current for LPR spouse? No. So in that case, the I-130 has to be filed first, and then the green card application later, if once the person's visa date becomes current. The reason why this doesn't come up as much is because for spouses of green card holders, their visas are usually current. So you would usually file it concurrently, but you would always want to double, triple check. If another type of visa opportunity becomes available while waiting for the I-130 or visa process, can the beneficiary apply for it? That would depend. So the green card and immigrant visa processes are categorized as having immigrant intent. And so you would have to pursue another status that has dual intent. Otherwise, you kind of compromise both. You wouldn't qualify for a non-immigrant status if you're already in the process of an immigrant one. How combined finances could be shown if a spouse lives abroad? Yeah, so this, just by nature of it, of the consular process, this may not be a category of proof that you have, just because the US citizen may not be living abroad with their spouse. They may be here in the US, and that's fine. We would just look to other proof and supplement with other evidence of your relationship. Are they looking at social media for proof? Our social media websites don't show our marriage, but do have engagement. We married privately. Okay, this is a great point. Social media. So not only are officers going to look at what you have submitted, they can look at what's public. So they can and they do look at social media. And so you'll want to be mindful of what's on there. I think this particular question is getting at, like, there was a ceremony that was held privately, which may conflict with what records look like, and like with what the date on your marriage certificate looks like. I assume that's what you're getting at. It may come up, but that's pretty easily explainable. Like, the reasonable explanation for that. People often have religious ceremonies or other private ceremonies on a different day than their legal marriage. So as long as you can explain. But I want the takeaway here to be that be mindful of your social media and what's on there. Okay. Because my husband's living abroad, we don't have anything with both our names on it. I think we kind of addressed this. So a non-citizen may not be able to have a joint bank account, but that's not a deal breaker here. We can look to other proof as well. Is there any benefit if you already have a child together? Yes. That's one proof of bona fide marriage that I didn't list there because it didn't really neatly fit in any bucket. But yeah, of course, if you have kids together, we'll want to show their birth certificates and show the government that joint project. Okay. When do financial documents need to be submitted? In the immigrant visa process, it's going to be submitted during the NVC stage. So on that website, but then we'll also update them, or you'll want to update them at the interview as well. How about if I'm a student here in the US? If you could provide a little more information for this question, I wonder if you're asking, if you're a student here in the US, can you change status to a permanent resident? Generally, yes, but you'll want to talk about your specific circumstances. How much does a spouse with 2 children have to earn per year? Oh, I haven't memorized the income guidelines, but they're available online on USCIS's website. If you look up income guidelines there, there's a grid. So it'll have like the number of people in the household and then the corresponding amount that the financial sponsor has to earn. Is it quicker to go for an EB1C through work via L1A AOS for ROW or a marriage-based green card? That depends. I would say as of right now, it's looking pretty similar. And we do have attorneys on our team that do work on EB1C, so they might be able to advise on more recent trends, but these are both green card processes, so the timeline could look pretty similar. I would say that employment-based green cards tend to process quicker. Okay, what if your last tax return demonstrates a low income, but you recently got a new, much higher paying job that's actually higher, but tax returns wouldn't note that? I have a lot of folks who are in this situation, like maybe they weren't earning a ton in previous years, but they've just landed like their dream job, and they will. I would say, so we can provide like a job offer letter and recent pay stubs to show that you meet the requirement. But if we're not confident that by the time we get to the next stage that you'll have a tax return that reflects the new income, I would still recommend getting a joint sponsor. USCIS loves to nitpick at this issue. So I think just to simplify things, it's really helpful to get a joint sponsor. The I-130 is rejected and we resubmit as directed. Does the processing time start over? Well, when cases get rejected, it's pretty quickly after they've been submitted. So you wouldn't be losing that much time. They will recognize when the service centers do their initial screening of the application, they're looking at, are all the pages of the forms there? Are the checks the correct amount? Have the checks cleared? They're looking at very preliminary requirements. And so they'll reject for that reason. If it's a more substantive issue, like we want to see more proof of your marriage, or we're not quite sure that you meet the income guideline, they would probably not reject for that. They're going to issue a request for evidence later. So that means that the processing time isn't starting over, but it's gonna pause. Once everything pauses when they issue a request for evidence, because they need you to respond to it. How long do you have left on your L1A to submit an AOS? Oh, this is not my expertise, so I won't speak to this, but our team here would be great to consult with. We have attorneys that specialize in L1As. I don't want to misspeak. Is it mandatory to meet the earnings for the spouse? Yes, otherwise you've got to get a joint sponsor. Can you provide proof of income such as pay slips? If tax pay slips, I think maybe tax returns is what you mean, are for a lesser amount. I would reiterate what I said before. So pay stubs could show that you will meet the requirement, but they really, really want to see it on the tax return. So it's best to get a joint sponsor there. What difficulties could I face when filing as my spouse, US citizen, has a child with their ex-partner? I don't think that fact alone could create difficulty. I'd want to know more. So was your spouse previously married? Like, what was the circumstances of that? Were they petitioned by that spouse? Are there kind of immigration related things going on there? But I think this fact alone doesn't really hurt anybody. Oh, I see. Okay. Okay. Gotcha. So this is like a situation where I might want to utilize an affidavit. So there are instances where, there are problems in a marriage, people separate, people take a break, and then they come back together and they decide to move forward. And there would be no documentation really that I've named that could explain that, but an affidavit could. And you can tell your story in a real way to show like the journey that you guys went on, and explain that. And in this situation, I would probably recommend an affidavit. Okay. I would also, well, I'll stop there. Okay. Approximately how much should you assume to pay for attorney's fees? That really, really, really depends. I think, we are a private firm and a boutique firm. So the fees at our firm tend to be higher. And then on the other side of it, there are nonprofits that have accredited representatives, they're non-attorneys, but they're distinct in that they've gone through the training and they have the certification to practice exclusively immigration law only with that nonprofit. And those entities tend to charge very low or nominal fees. And you're getting still high quality representation. So I think the fees really, really vary. And the type of service is also going to vary. So it just kind of depends. Okay. I think I answered everything. I can't believe it. Okay. If you still have more questions, please feel free to contact our firm. Let me do this first. Please follow us on all of our socials. We would so appreciate that. Our marketing manager, Liz, would love me if you did that. And here they all are. I'll just leave this here. But as a thank you to everyone who attends or views this webinar later, if you do schedule a consultation with us and then end up hiring us, we are happy to credit the consultation fee back to you just as a thank you. So I think that's all I have today. Hopefully you found this information very helpful. And we're here if you have any questions, if you want to talk through your case and your circumstances. So thank you so much. Bye, everybody.